Internal investigations. Every company in this room today has conducted one at some point. As regulatory scrutiny increases, whistleblower claims proliferate, shareholders assert claims, and the need for a cogent internal investigation policy becomes critical. I'd like to introduce to you Bill Cronin with the Corr Cronin firm in Seattle. Bill is a fellow in the American College of Trial Lawyers, and he has been named as one of the top business litigators in Seattle in every one of Seattle Magazine's top lawyer surveys since 2001. For 8 years in a row, Bill has been listed in Best Lawyers in America. He has also been selected as a super lawyer on multiple occasions by Washington Law and Politics and has been named as one of the top 100 super lawyers in the state. Bill has represented law firms, accounting firms, corporate officers and directors, and majority and minority stockholders in securities litigation, professional liability litigation, and corporate control disputes. He has represented giants like Exxon, Georgia Pacific, AT&T Wireless, Champion International, and Amazon.com. Here to discuss issues for counsel and internal investigations, please welcome Bill Cronin.
Thank you and good morning. I must tell you what a pleasure it is to be here yesterday and today. When I left Seattle yesterday, we were in the midst of a torrential downpour, and to arrive and encounter this weather is nothing better than extraordinarily sweet. What I want to focus on today is the ethical issues associated with internal investigations. I think it's generally acknowledged that internal investigations are on the rise. There are numbers of reasons for that. There are whistleblower statutes that are in place. There are internal company policies that call for internal investigations. There are workplace rules that call for internal investigations. There are increased financial reporting requirements that often require internal investigations. But I'm not going to go into all the reasons for internal investigations. I just want to talk to you about some of the ethical issues that you must be mindful of in connection with conducting an internal investigation. Now, in my presentation, I'm going to draw a parallel. And I'm going to draw a parallel between the role of a whitewater river guide and the role of the person who is directing and steering the internal investigation. And you may ask, what possibly could be the relationship between these two activities? But I hope when I'm finished you have some understanding of what the parallels are and how the parallels may be informative to you in deciding how to comply with the ethical issues that arise. I'm going to begin by playing a video. A long time ago and far away, I was an ardent whitewater river rafter, and river rafted many of the rivers in Washington, Oregon, Idaho, and California. But I've abandoned that activity, and my wife is very happy about that. But I'm going to play you a short video from a river rafting trip down the Colorado River. And I need to assure you, no one was hurt in this river rafting trip, but it sort of illustrates the problems that arise in a metaphorical sense with the investigation that gets off course.
Group, they're way out there. Doing the right run. Oh my God. My God. Oh my God. They're stuck. Let me take a picture. Oh my God. Get out of there, guys. No, they're stuck. Oh my God. Where are they? Look at the boat.
There always is an onlooker who wants to take a picture when people are in trouble. You just hope there's no onlooker like that if your internal investigation is in trouble. What I want to do is, though, draw the parallels for you now. In connection with river running, there are certain rules that you follow. The first rule is that you must, before you begin going through a set of rapids, you need to scout the rapids, and you need to pick your course. And you need to do that before you enter the rapids. You can't be ad hoc selecting a new course as you enter the rapids. You need to pick your course. And the parallel to that in connection with an internal investigation is you need to identify very early in the internal investigation who your client is. And the ethical rules, ABA Model Rule 1.13, discusses the considerations that you must be mindful of if your client is an organization. I'm sure many people here either represent organizations or work for organizations, and therefore they must be mindful of these considerations in order to assure ethical compliance in selecting and identifying the client. This is ethical. This is the ABA Model Rule 1.13. I'd like to call your attention to two sections of this ethical rule, Section A and Section F. Section A requires you as a lawyer to represent the organization by acting through its duly authorized constituents. And for in-house counsel in particular, your constituency can change daily. You may be advising a CEO at one point in time, a CFO at another point in time, other employees at other points in time, sometimes the board of directors. And what the internal investigation does is often it presents a challenge for in-house counsel to identify precisely who their client is. I'll give you an example. I had a client who was in-house counsel for a company in Seattle. She was in her office. She regularly consulted with the CEO, a CFO, and advised the board of directors. One day, the CFO showed up in her office and basically told her that he believed that the organization had been improperly reporting expenditures to the federal government and that the CEO had been directing the improper reporting. For her, the immediate problem is, okay, who's my client? It's not the CEO under that circumstance. It's no longer the CFO. It ultimately became the audit committee for the board of directors. So it's incumbent upon you, in order to comply with this ethical rule, to make sure you identify at the very beginning who the client is and make sure your communications are with that client and not with other folks about the subject matter of the investigation. And that's really what Section F of this model rule is all about. So just like charting a course through rapids in connection with a whitewater rafting trip, you need to select your client and chart your course with that client through the internal investigation. A second parallel I want to draw for you, well, before I get to that, let me just summarize for you what you must do to put the investigation on course. You identify your client constituency, you report to that client constituency, and you clarify for all concerned who you can advise and who you cannot. So in the circumstance I just described, you would be communicating to the CEO and the CFO that you cannot advise them any further about the subject matter of the report that you received from the CEO about the alleged fraudulent request for reimbursement to the federal government. Now, second thing you do in a river rafting trip is once you're in the set of rapids, you avoid the rocks and the holes because either large boulders or potholes can flip your raft. Same thing with an internal investigation. Once you're into the internal investigation, you need to make sure you've selected the right investigative counsel. And in that connection, there are ethical rules to consider. One, you need to ask yourself the question, is the investigative counsel who I want to use, do they have a potential conflict of interest? Second, you want to ask yourself the question, does the investigative counsel, are they a potential witness to the subject matter of the investigation? If you look at these rules, I think there are some practical pointers that I would give you in connection with the selection of counsel to conduct the investigation. And here's the practical pointers. Basically, A law firm who routinely counsels on the subject matter of the investigation may be a risky choice. An example is when Enron was in difficulty, they hired Vincent and Elkins to conduct an internal investigation about the financial transactions that were at issue in that investigation. Unfortunately, Vincent and Elkins had actually provided legal advice about the subject matter of those transactions. And what that meant is, no matter how effective the Vincent and Elkins investigation was, it was largely discredited because of this conflict of interest. Second rule I suggest you follow is if you have a law firm who has counseled the likely interviewees, that is, an outside law firm who's been counseling the CFO, for example, about issues that might be implicated in the subject matter of the investigation, that's also a risky choice for the purpose of conducting the investigation. You may find that outside counsel may be a witness. Maybe they provided advice to the CFO that ultimately becomes part of the focus of the investigation. And the third rule I want to give you with regard to selection of outside counsel is, if you have a law firm who's previously counseled a person who is the possible target of the investigation, they're a bad choice to conduct the investigation. So in the circumstance I just described of the friend of mine who was in-house counsel for the company in Seattle, once the CEO has been targeted or identified as potentially the person who has directed the fraudulent reporting to the company, you don't want to hire an outside law firm who's been regularly consulting with the CFO. It just creates too many risks and puts, I think, in jeopardy the investigation. Now, I want to speak to you briefly about a case that arose. Actually, it's a series of cases that arose in California. These are the Rule cases. Bill Rule was a CFO for a company in California called Broadcom. What was at issue was a series of stock option granting practices at Broadcom. Broadcom had an outside law firm, Irell & Manella, a very respected, very distinguished firm. They had been the go-to outside counsel for Broadcom during the course of Broadcom's growth and history. Irell & Manella had also represented Bill Rule in connection with 2 lawsuits that had been filed against Broadcom relating to the stock option grant practices. Irell & Manella had also conducted an internal investigation for Broadcom and interviewed Bill Rule. And Irell and Manella ultimately reported the results of their interview with Bill Rule to the outside auditors, Ernst & Young, to the SEC, and to the U.S. Attorney's Office. This caused problems. And in a case that was filed in federal district court by Bill Rule against Irell and Manella, Judge Cormac Carney was very disturbed by Irell and Manella's behavior, at least as he saw it. Basically, he advised that he thought that based on what had occurred in the history of the relationships, that Irell and Manella had breached his duty of loyalty to Bill Rule in making the decision to disclose information from the interview to the outside auditors and to the SEC and the U.S. Attorney's Office. Beyond that, Cormac Carney concluded that Irell's misconduct was of a nature that he took it upon himself to report Irell to the State Bar of California. You don't want to be in that position, and you can avoid this kind of problem if you're careful in the selection of outside counsel. Now, fortunately for Irell, the Ninth Circuit reviewed Judge Cormac Carney's ruling and found that during the course of the interview, Irell had communicated to Rule that they would use the contents of the interview and disclose them to the outside auditors. And the Ninth Circuit found that with that communication, that really Rule had no legitimate expectation that that communication with Irell was privileged or confidential. So the Ninth Circuit fortunately salvaged Irell from what would have been a very unfortunate circumstance. The third part of avoiding the rocks and holes during the conduct of an investigation is making sure that you conduct the interviews properly. And there is an ethical rule about that. If we can, we'll look at ABA Model Rule 4.3. It's called Dealing with the Unrepresented Person. And first of all, outside counsel, whoever they are, or it could be an in-house counsel, who conducts the investigation has to be very careful to make sure they communicate to every interviewee who they represent and who they don't represent. I think there's a best practice in this regard, and I've described the best practice regarding the interview in this slide. And here's what I think the best practice is. I think that the lawyers involved need to communicate to each person they interview during the course of the investigation exactly who they represent and who they don't represent. I think they need to communicate to the interviewee, assuming this communication for the interview with the interviewee qualifies as privilege under Upjohn. I think they need to communicate to the interviewee that the privilege probably exists. They may, in certain circumstances, want to advise the interviewee of the opportunity for personal counsel. I don't think this is needed in most circumstances. In some few circumstances, I think it is a best practice. And they also want to advise the interviewee during the course of the interview that there may be a later disclosure of the contents of the interview. In other words, someone may decide at some later point that the corporation will benefit from waiving whatever privilege might apply to the communication and have the communication disclosed to third parties, maybe the auditors, maybe the SEC, maybe the U.S. Attorney's Office. But you want to preserve the opportunity to do that. And that draws me to the third parallel I want to draw between river rafting and conducting an internal investigation that's consistent with the ethical rules. What you want to do in connection with an internal investigation is you want to make sure you preserve your options, and that is done best by communicating some of the information I've described to the persons who are interviewed. If you're navigating or if you're a river guide on a whitewater river raft trip, before you enter the rapids, you always want to know what are your landing options in case you have difficulty once you get into the rapids. In the same way, when you're doing an internal investigation, you always want to preserve your opportunities to get the biggest bang for your buck out of the investigation. It may mean that you decide you don't want to conclude the investigation with a written report. There are reasons why you may not want to put the results of the investigation in writing, and you're certainly not required to do so. So you want to preserve the opportunity at the end of the investigation to make the decision whether you want a report in writing or whether you want to make an oral report to the audit committee or to whoever the client constituency is for the purposes of the investigation. You want to make sure that you keep the contents of the investigation and the communications about the investigation restricted so you can preserve whatever privilege applies to the investigation. There have been circumstances involving very fine law firms and very large companies where, to illustrate, a director is accused of wrongdoing, a special litigation committee is appointed to conduct an investigation into the director's wrongdoing, a report is generated, and then the report is shared with the entire board. Well, that's a problem because the entire board is generally not in charge of the investigation. It's usually a special litigation committee, and by that conduct, and it's easy to fall into the pattern of this kind of communication. You may have actually waived whatever privilege might have applied to the investigative report. But you also want to always preserve the opportunity to waive the privilege issue, assuming you preserved it. And you will want to do that because very often there is an advantage to be gained with regulatory authorities by providing them with copies of a written investigative report if you conclude that's in your best interest. So I hope I've provided you with some guidance in connection with complying with the ethical rules. I don't think this equips you at all to get in a raft and start oaring through a difficult set of rapids, but there are some parallels that can be drawn between these two activities. And I think keeping in mind the parallels will help you keep in mind what your ethical obligations are. Thank you very much.